You're watching Bloomberg Law. I'm Lee Pacquiao. Last week, a new company backed by Google executives and filmmaker James Cameron, among others, announced plans to start mining near-Earth asteroids for precious metals and water. My guest today says that once you get past the technological challenges facing planetary resources, that's the name of the new company, there are real legal issues that need to be addressed. For example, who should be able to lay claim to an asteroid? Joining me now via Skype, I'm happy to say we have Professor Frans van der Donck, Professor of Space Law at the University of Nebraska-Lincoln College of Law. Professor, thank you so much for joining us today. Welcome to the program.
Thank you very much.
So, okay, before we get to the law, I got to say, I've been looking forward to doing this story all week. What should we make of this news? Is there a serious chance that we could see a private company mining asteroids for gold and platinum in 10 years' time?
Absolutely. I think it's always a little bit of looking into a crystal ball, but the technology is rapidly being developed. The Japanese, a couple of years ago, have actually made a robot landing on an asteroid. So I'm certain that technologically speaking, it's possible within that time frame, yes.
And the economics are certainly very favorable. There's been articles out this week saying that a single asteroid, a single rock, could hold something to the tune of $1 trillion of raw material assets, cadmium, platinum, gold, even water is valuable at that level. So there's certainly an economic incentive for this new venture to get to where it needs to be. Professor, as you know, but my audience may not, we actually have law governing stuff like this. The 1967 Outer Space Treaty, I guess the relevant part of it would be Article 2, which reads, outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. This could mean a couple things in this particular circumstance. What do you say about it? Does that mean that it only applies to sovereign nations, or does it mean that no one owns anything in space?
Well, that's a very good question, and the answer to that tells you that in 1967, for sure, nobody thought something like this was possible, certainly not with private money. Because the long and short of Article 2 is that, as a consequence thereof, no single state can exercise territorial sovereignty over outer space, and this means in turn that no state can apply its national laws to outer space as if it was, say, a U.S. territory. And if you talk about private appropriation, private mining, obviously you need a government to regulate that, to regulate the licensing, to regulate the conditions under which the license can be given. And normally speaking, such licenses under the control of a government are only applicable to the territory of that very government. But since an asteroid can never be part of the territory of one state or another, by definition, these laws about how to mine and what the conditions are cannot as such apply to the moon or any asteroid.
What other issues do you see cropping up once a project like this gets off the ground, so to speak?
Well, one thing which should bother the private operators themselves, of course, is the legal certainty that they have. Everything they extracted out there is not going to be interfered with without any legal defense. The nice thing of a global commons is that everybody is in principle entitled to make use and explore and to a certain extent exploit that, but it also does not put any boundaries on others to respect the exploitation of one particular group or another, and that is something which is missing. Another issue which is very important is the liability issue. Again, there has been a specific convention drafted in the early 1970s to address liability in space in general, but nobody foresaw this type of event happening. So what if the company in mining an asteroid inadvertently causes parts of that asteroid to get into the orbit of a valuable communication satellite? Does that liability regime, which was not developed for those type of circumstances, does it apply? Would it apply? Or even worse, if some part of that asteroid would then change its original trajectory and start heading for Earth, is there any liability and responsibility involved in that? or to give you a last example of liability, what happens if another company piggies on the exploration efforts of the first one, Planetary Resources as an example, but make sure it gets first to the actual asteroid and then says, haha, we were here first. So we are the ones who are now going to benefit from this. Is there any liability for missed revenues or for exploration investment? And obviously we're not talking about a few thousands or even a few millions. We're talking about huge sums of money.
No, these are big numbers for sure. You have said previously that we have a template for governing issues like this from the laws that currently govern seabed mining. Can you walk us through that?
Yeah, well, I think template is a little bit too strong a word. The main reason why many people refer to the seabed is that, like the outer space, the seabed is a global commons. And there, indeed, we have now had US and some other companies being licensed to mine the seabed, where apparently also very valuable natural resources are made available, licensed on an individual level. But the key difference is that we do have a quite elaborate law of the sea regime, which does provide for a number of conditions under which, for example, the United States can license such a company, which provides for obligations and rights of both the United States as a licensing government and companies so respect, so that a company operating with a license under those conditions can rest pretty sure that its entitlement to whatever is going to be mined will be respected in a legal context. And that is precisely what is missing so far in outer space.
Professor, are these kinds of issues even being contemplated at the higher levels of government, whether in the United States or on the international level? Is this something that politicians and regulators are thinking about?
Absolutely. And I think they do very well, obviously, to do so. It's interesting that a totally different part of asteroids is, or a different aspect, I should say, of asteroids has already been discussed for about a decade now, including some of the legal aspects, and that concerns the threat that some of them may pose to the Earth. What are we going to do as an international community, or perhaps even as the United States, being the single most advanced nation with the technology capable of changing the trajectory of an asteroid in terms of its speed, not in terms of its direction, but in terms of its speed. But that should be sufficient. And what I noted with interest is that one of the people involved in Planetary Resources is Tom Jones, former shuttle astronaut.
That's right.
Who is very involved in these discussions, which also take place currently at the United Nations on what are we going to do if an asteroid has our name on it. And I have had the privilege to work with him on this project a number of years ago, and we did a little legal study. And interestingly enough, in the context of that study, the possibility also arose to use private investment to help the public cause here. And of course, it would be interesting that if private financiers like Planetary Resources would be willing to finance an operation like that, and in the course of that, diminish the risk of that asteroid ever going to hit Earth, that will be a very valuable thing to consider. So the legal aspects of that, and should we somehow create a regime which does give a private company like Planetary Resources property rights over an asteroid, these discussions are taking place currently in the United Nations. So to come back to your original question, yes, the issue has certainly been addressed, at least from several angles now, as of now.
Yeah, it's interesting when we talk about areas in which technology and the law intersect. Usually technology vastly outpaces the ability of regulators and lawmakers to play catch up and get some level of feeling as to that which they're dealing with. But it sounds like here there's a little bit of a sense that everyone is more on the same page. Professor Frans van der Donck, I want to thank you so much for your time today, sir.
You're more than welcome. Thank you.
That's Professor Frans van der Donck from the University of Nebraska-Lincoln College of Law. If you'd like to learn more about the issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Pacquiao. Thanks for watching.